All right, good morning, everyone. Thank you for joining us. My name is Catherine Spitz, and with me today is Lucas Vebber. We are both attorneys with the Wisconsin Institute for Law and Liberty, and as part of our Preserving Democracy project, which Lucas spearheads for us, we recently released a guide to public records and open meetings and holding government accountable. And so we are holding this webinar to expand on that a bit today. Lucas and I will go back and forth and may jump in when the other is talking to add something here or there. If you do have questions as we're going through, please feel free to ask them in the chat and we will do our best to get to them. Lucas, why don't you go ahead and put that PowerPoint up if you would. Fantastic, thank you. So a little bit about us here at Will. In addition to the transparency issues that we're covering here today. Get my notes back up here. You can see that we also litigate and do policy work in a number of areas, separation of powers, regulatory ingress into society, economic freedom. We do a lot of First Amendment issues, primarily revolving around freedom of speech and freedom of religion. We also do a fair number of cases that involve educational freedom and our Equality Under the Law initiative. In addition to the litigation that we do, we also have a policy arm that provides policy research and advocacy to advance reforms in a number of the same areas. So that is a little bit about what we do here at Will. We can go to the next slide and we can talk about today's agenda a little bit. You may not be surprised to see that it tracks quite largely the guide that we put out. We're going to start by talking about public records, including how to make a request and how to deal with delays and denials, or basically when government behaves badly. And then we will move on and talk a bit about open meetings, the importance, things to look for. And again, if you find that you are dealing with a government entity that is not complying with the open meetings rules, how you can deal with that. All right, so let's just launch right into it and we can talk a little bit about our public records law. You can see here, it's covered in Chapter 19 of the statutes, not that all of you are lawyers or need to know where to find it, but in a nutshell, local, state and local governments and state and local government employees, when dealing with official business, are covered by the public records law. So it covers a very wide expanse of records. If we are talking paper records, we're talking electronic records. So that might be emails, text messages, social media posts, if done in the employee's professional capacity. So we're not talking about if you have a government employee who on their personal time is, having an Instagram account that has nothing to do with their job. That's not a public record. But if you have, for example, the mayor communicating with other people on staff about official government business, that's the sort of thing that's going to fall into the broader definition of a record. So it could be policies, it could be email and text, but it's not going to include things like personal drafts or personal communications between a public official and, say, their spouse about what, when to pick up the kids or what the grocery list is. Folks obviously should not be using official emails for non-government business, but occasionally it does happen, but that does not necessarily in all cases make them public records. So just something to keep in mind. Another thing to keep in mind in terms of, I guess, what is covered is that our state law does not apply to the federal government and FOIA does not apply to the state government. Try not to use the wrong terminology when you're using requests, although as we'll talk about in a few minutes, that actually doesn't necessarily disqualify the request. It just means that you made a little bit of a technical boo-boo, and generally speaking, most government entities are going to comply anyway. But the point is that state and federal law are different. So if you're looking for records under the state law, make sure that you're asking from a state or local entity. All right, we'll go ahead and go to the next slide. Records requests, they don't require a particular format or magic words. You don't have to cite the statute. You don't have to go, for example, to the police department and say, pursuant to Wisconsin statute 19.37, I hereby demand that you give me the following records. It can be pretty simple. You do not have to follow a particular format or a form. Essentially, if you are asking for something that is a public record, if you're asking for a policy or for emails between officials, just giving the official the idea of what you're looking for is going to suffice under the statute. because Wisconsin courts have held that our public records laws are supposed to be interpreted in such a way as to afford the broadest presumption of access whenever available, consistent with the conduct of government business. So some public offices may try to tell you that you have to make a request in writing or that you have to do it in person. That's not the law. So keep that in mind. And doing that however you need to do it is generally going to work. That being said, while you don't have to use a particular form or format, it may be easier to track if a government entity offers one. So if you go on to, say, the City of Milwaukee's website and they have a form for a public records request, it may simply be easier to fill that out than to try to locate the right person to email and then put your own request in writing. Okay, so based on that, here are a couple of tips for effective records requests. I've got here, think about why you want what you want. So in other words, it can be super easy for you to say, I want this official's emails between himself and these 3 members of his staff for a 12-month period, for a year, right? You could make that request. You may face a time limitation on that. A court may not give it to you, but the point is, are you really looking for every email that official sent with these 3 people for 12 months? Because not only are you putting the burden on the government to produce that to you, which maybe you don't care about, and that's fine, but you're putting the burden on yourself to actually have to go through any records that you get back and look for what you're really interested in. So I would always advise people to, think about what the subject matter is, or, why you want what you want, and to include limitations appropriately. As I mentioned, consider the cost to you of making an overbroad request. And that's not just in terms of your time, but also potentially in terms of money, because although the government cannot charge you for certain things that they do with regard to public records, they are authorized under the law to charge you for locating records, particularly if you're looking for something that's far back, not easy to find, for copying records if you're doing things in a hard copy format, or it's not the sort of thing that can just be easily scanned or generated electronically. And then also the shipping costs. So if you are requesting hard copy records and they're going to be mailed to you, then the government can charge you for those costs. So, keep in mind when you make a request that it's often the most effective to do so in electronic format, or to request the records in electronic format, so that you're not paying for some of those costs that are associated with what is generally hard copy requests. And then just sort of a basic rule that I like to have, and it's true both in the transparency area as well as everywhere else: do your best to treat others the way that you'd want to be treated when you're conversing with government officials and making requests. Don't go into this assuming that they're not going to give you what you want, or that they're against you, or that they don't want to comply. You will, of course, occasionally run into somebody like that who just doesn't seem to be interested in obeying the law and doing their job. And Lucas and I are going to talk here about how to deal with that in a couple of minutes. But, for the most part, these folks are just, they're government workers. They're workers like you and me. They're doing their job. And you're generally going to get more flies with honey than you are with vinegar. To the extent that there is any sort of wiggle room or discretion, or there's a question about the request, you're way better off just being, polite, straightforward with whoever you're dealing with, instead of, reaming them out for not responding exactly the way you wanted to when you wanted them to. And also to keep in mind with that, if you do end up in litigation, all of your requests or exchanges with those folks are going to be part of that record. And so think about how it's going to look if you are, jumping down somebody's throat in an email and that ends up in front of the judge. So last thing, I guess, the tips for effective document requests. Again, don't ask for things that you're not entitled to. The records law is pretty broad, but it doesn't cover things like an official's personal health records, or if you're talking about things in a school, you can't ask for another student's records. There are exemptions in the law. You're not entitled to everything. So just be mindful of asking only for those things, one, that you actually need and want, and two, that are available and authorized under the law. As I mentioned, don't cast such a broad net as to defeat your underlying purpose. And I'm sure this one goes without saying, and nobody on this webinar is going to do this, but do not use records requests for improper purposes, such as harassing an ex or just harassing an official in general. The public records law is there to provide information to us as citizens about how our government functions and what is being done with government time and our tax dollars. It's not to be used as a political or other harassment tool. All right, and then the other thing here before I throw it off to Lucas for a little bit is some best practices to consider. Well, of course, you can make a request in any number of ways, as I've mentioned. Written requests, especially email, typically tends to be the easiest to track. So if you do a request by email and you don't hear anything for a week, of course, it's pretty easy to just hit forward, send it to the same person, and politely request an update. So that's the easiest way that you can sort of keep track as to how your request is proceeding. And then if you have to resort to filing a lawsuit, you have everything that you need right there in terms of dates and when you were trying to communicate with these folks. As I've mentioned, be as specific as possible as to dates or search terms. It helps both the government and you in terms of making a request, and you're less likely to make a mistake. I also have here avoid sticker shock. And what I mean by that is, as I mentioned, you can be charged for location costs, copying costs, shipping costs. And at the outset of your request, you probably don't know if you're going to be getting 50 pages or 500 pages of documents in response to what you've asked for. And so it's a good idea, if you can, to limit your request in some way when you make the request, to say, hey, if this is going to cost more than $50 to fulfill, or whatever your limit is, please contact me before proceeding, because you may decide that you either are getting too many documents where it won't be useful, or are going to be charged too much, and you may want to narrow your request. Now, there are some times, and I'm sure Lucas will probably touch on this, where we have seen government officials use costs as sort of a deterrent, or abusing that to try to discourage folks from making requests. And we're in no way suggesting that that's right. But keep in mind that if you put a limit on that at the outset, you're more likely to have a productive conversation up front. And then last here, I've said ask for updates or a timeline. If you're not hearing back from the government and it's been 10 days and the request hasn't even been acknowledged, it's perfectly appropriate to follow up and see when you can expect to receive a response. Not all requests are the same. They're not going to be dealt with on the same timeline, but if you have a question, it's okay to ask. What it's not okay to do, of course, is to bother the person every 3 hours and say, when are you going to make these copies for me? So it all kind of comes down to a general rule of just be reasonable.
So with that, I'm going to jump in and talk about, once the request has been made, anybody who's made a public records request probably has been frustrated by delays at some point in the process. So what exactly is required? The statute simply requires that the authority, the public records holder, respond to you as soon as practicable and without delay. So there's no hard deadline in the statute. Now, our Attorney General, who issues a guide on this as advice to public officials, generally says 10 business days for a simple request is a reasonable time, would be as soon as practicable and without delay. That's just a guideline. So it really depends on the nature of your individual request. And in some cases, you've got, one public official. If something big happens, maybe that official has, dozens of requests coming in. It's going to take them a little bit of time to fulfill it. And certainly when there's a number of requests coming in, they also have to do their public job as well, although obviously responding to records is incredibly important. But so there could be reasons for the delay. That being said, a government body or an official, they can't just delay indefinitely for weeks or months, or in some cases years, before they respond to your request. It's unreasonable, no matter how complicated the request is. At some point, that's an unreasonable delay. But it doesn't mean, and I think the important thing here is that there can't be some delay before you get a response or the records themselves. It might be a week before they respond and say they received it, or 2 weeks until you get the records or something. And those are all acceptable delays. You don't want to be running into court after 2 weeks. A judge will not look very kindly on that. So what is an unreasonable delay? As I said, it really depends. It's very subjective. It depends on the individual record that was requested, the person or the entity that you're requesting it from. Everything from the scope of the request, which would be the date range. Are you looking for a specific email from a specific day, or are you looking for all records from a very long period of time? Are you looking for one specific topic or a very broad topic? What types of information are you seeking? Are you seeking communications? If you seek communications, what we usually do when we do these requests is to make clear what that includes, but not limit it. So we always say, we want all your correspondence, including email, text messages, anything you've written to somebody, but we're not trying to limit it to those. We're just giving some examples. There's more and more of these electronic messaging apps that are out there, anything from Signal to Facebook Messenger to WhatsApp. You want to make sure that you make clear that all of those are part of your request, and you don't want to give them a reason to avoid searching through any of that. But things, and if you do, and if it's very broad like that, it's going to take more time. But some of the other, an unreasonable delay, if your request has been pending for a couple months, it's probably getting in the unreasonable delay territory. As Kate said, you want to make sure you're using honey on this, and just be polite with them and just reach out and say, hey, it's been a couple months. I haven't received my records. Could you let me know what's going on, or when I can expect to receive them, a rough estimate? In most cases, the public official is going to respond and try to give you some kind of a timeline. And then, you can hold them to that and follow up after that time. Other factors that go into the unreasonable delay, just how many do they have staff available to do this? If you're requesting it from a small township that maybe has one full-time employee, it might take a little longer. If you're not receiving any kind of response from them at all, if you're just getting completely ghosted from the public authority, and it's been a month, it's been longer, that's probably getting into the unreasonable delay territory. So what are the do's and don'ts here? If you're experiencing a delay, you want to make sure you're creating a record, okay? Anything that doesn't happen in writing, just assume that it didn't happen. So if you're going to call somebody and talk to them, make sure you follow up with something in writing. Try to get an acknowledgement in writing from them. Email is fine. You want to make sure that you can work with that official or the office and just get a timeline. Like I said, just ask them for, hey, when do you think you can get this to me by? And then follow up politely at that time. You want to ask questions if there's going to be reasons for that delay. And in some cases, they'll say, hey, this is going to take us a long time to get all these records together because X, Y, Z. There might be a chance for you to narrow that request and say, oh, well, you're looking for records that I might not actually want or need. Here's what I really need. In many cases, our experience is if you just talk to a public official and tell them what specifically you're looking for, they can actually help you craft that request. I mean, it makes their life a lot easier, and it'll make your life a lot easier, and it makes the request come through a lot faster. So the do nots here, don't expect that all government offices can respond in the same timeline or have the same process. If you're requesting it from a large office, they might have more staff to respond to records requests, but they probably also have a lot more records to look at. So it really kind of, it depends on so many factors that go into it. And again, following up on kind of the theme that Kate was saying earlier, don't take your frustration out on the individual handling the request. In many cases, they've got a lot of stuff they have to search through or try to coordinate through, and it's probably not even their fault that something's being delayed. But be polite, be firm, make sure everything's in writing, but no need to take out any kind of abuse on any sort of public official who's not responding. So what happens? When can government actually deny your request? So when you make a request to a government entity, to a public authority here, they have a couple of options. They can turn over all the records you sought. That's ideal. They can turn over all the records with redactions. So like they could redact a social security number or things along those lines that are laid out in statute beyond the scope of this presentation today. They could turn over some records and withhold other records, depending on if they're disclosable or not. Or they could withhold all the records that you requested. And in all but the first example, they have to give you a written explanation of the denial or the partial denial. State law requires them to do that. So some of the reasons that they could deny or partially deny would be if it falls under a statutory exemption. So for example, purely personal records, as Kate said, an email between a husband and wife, not going to be a public record, very likely. Copyrighted or patented information, not a public record. Published material that's for sale, like a book or something you can get at your local library, they're not required to turn that over for you. You can go get it somewhere else. Drafts, which can be particularly frustrating if you're requesting public records from like the legislature. Drafts are not public records, so earlier versions of certain things may not be available to you. And then, of course, healthcare records, student records, these things aren't going to be turned over in public records. In every case, the authority is going to conduct what's called a balancing test. So they weigh the public's interest in turning it over with the interest in not turning it over against the interest in not turning it over. And they just have to conduct that balancing test. And every public authority has to do this when they turn records over. In many cases, that's going to result in the records being turned over. In other cases, it may not. So certain law enforcement records, if they're highly sensitive, might not get turned over. Names of minors, for example, and certain things aren't going to be turned over. And that's all subject to the balancing test that the Public Records Authority is required to do in every single case. Ultimately, if you get to the point where records have been denied and you believe it's unlawful or unreasonably so, you can advance to litigation. There is only one way to litigate these types of matters, and that's through what's called a writ of mandamus. Writ of mandamus is a very specific type of civil lawsuit, a civil action, in which the court can compel a government official to act. So the writ says, I command you to turn these records over. It would be issued by the court to a government official. You do this on your own or with an attorney. There's no need to involve your district attorney. With this, as Kate said, state law, not federal law. So this is state law governs when you're dealing with state or local officials here, okay? If you're dealing with the federal government, it's FOIA. With state or local, it's going to be state law. Damages are available in these cases, including punitive damages in some instances. And there is what's called a fee shift here. So if you are to file this lawsuit and you are successful at the end of the lawsuit, you get a court order in your favor, you may be able to recover your attorney fees and costs in this particular case. We note in here there was a recent Frame Park decision. This is a decision of the Wisconsin Supreme Court. It made it a little bit more difficult in some cases to get attorney fees. That's because Wisconsin's law hasn't been updated like FOIA was. Wisconsin courts had sort of been following along the lines of how the federal courts have interpreted FOIA. But once FOIA was updated, we just started sort of interpreting it as though Wisconsin law was updated, but it never was. And our Supreme Court in Frame Park essentially called that out and said, basically left it for the legislature to amend the law to ensure that you can continue to get your fees. So there is some question out there. Would certainly encourage you to contact an attorney at this case, if you're getting to this point. This is something that we do a little bit of work in. In most cases, we refer a lot of these cases to our good friend and former colleague, Tom Kamenik at the Wisconsin Transparency Project, who does this work full-time and is truly excellent in it. And there may be some other attorneys out there who would be willing to take this type of stuff on as well. With that, I will turn it back over to my colleague, Kate.
Okay, so on to open meetings. Open meetings are, I would say, kind of like the thorniest thing that local governments in particular, I would say, deal with. It's a lot easier to have a technical violation of the open meetings law than it is to just comply with the public records law in a lot of instances. Not saying that government doesn't also screw up records. Otherwise, we would have had no reason to talk about it for the last 20 minutes. But open meetings can be a little bit more complicated to assess and to get through. So what sorts of gatherings are subject to the open meetings law? So there's 3 basic requirements for that. It needs to be a government body created by the Constitution, statute, or other law that convenes for the purpose of conducting the governmental business for which it is charged in a sufficient number to make a decision. So not every sort of gathering of public officials is the sort of open meeting that is subject to notice and the requirements of the open meetings law. For example, it's not line staff. If a mayor wants to have a weekly staff meeting with all of his or her staff people to assign tasks or do status updates or whatever the case may be, that is not the sort of open meeting that would be subject to this law. Government would be completely unworkable if we had to do it that way, right? So what we're really talking about are basically the elected officials who have the power to make these decisions. So if you have a board of 7 supervisors and 5 of them get together and they talk about what they're going to vote on next month, that's a problem because the reason for the open meetings law is, again, to provide citizens like you and me with the ability to understand what's going on, the debate that is circulating around important issues. So folks can't get together and say, hey, I'd really rather not have the common council meeting go for 2 hours this month. Let's just shortcut it and meet ahead of time and decide how we're going to vote. Like that doesn't work. But those are the sorts of things that, people might run afoul of. The most frequent open meetings issues, as I've noted here, failure to give adequate notice of meetings or of what's actually going to be discussed either at the meeting or in a closed session, which Lucas is going to touch on closed sessions in a little detail here in a couple of minutes. Misuse and abuse of the closed session, people who want to try to use the closed session for basically having discussions out of the public view that should be in the public view. And then also some folks have had issues in terms of failing to make the meeting reasonably accessible to anyone who wants to attend. That is a requirement under the statute. And so holding a meeting in, a tiny conference room or something that is not accessible to folks who have physical disabilities, for example, that's the sort of violation that can occur if you're not careful. So I've got listed here a couple of examples of open meetings violations, sort of the one that I mentioned that's sort of the real, check the box, this is a big one, is if, say, the majority of a board of village trustees get together to debate some of the things on this month's agenda without it being part of the actual public meeting. If that's something that they have the power to decide that they're going to vote on that's public business, then that's not the sort of thing that you can do outside of the context of a properly noticed open meeting. And again, you can also do things on the other side. So if you have a board of 6, let's say for your village, that has to authorize whatever the next residential development is going to be. But your rules, your ordinances, and the governing law says that 2/3 have to approve something. If 3 of you get together and exchange emails or have a phone conversation even, or a text conversation regarding development and say, okay, we're all going to vote no, that is what's called a negative quorum. And so that would actually be enough to take action on something by saying we're going to vote no. So it doesn't have to be a physical meeting among people. It can be emails, it can be phone calls, it can be a series of conference calls in order to try to get to a majority outside of the public view. The basic problem, of course, with all of these sorts of violations is that public officials are debating and talking about issues that they are charged with voting on without doing so in full view of the public. So that's why those things are a problem. And then the other example here, basically it's the same thing. You can't sort of gang up and go to a meeting that you didn't notice and then all talk about an issue that you have the power to vote on. Okay, so we're good to go to the next one. And then here's some examples, and just as importantly, things that are not open meetings violations. If you see a couple of folks who are good friends, but also happen to be public officials that are just hanging out at the bar watching the Badger game or the Packer game, they're not having a meeting, even if there are enough of them to be an open meeting if they were discussing government business, because if they're just cheering for football or having a drink or whatever and not discussing government business, it's not a meeting. As I mentioned, administrative staff meetings or other sorts of divisions or units within a governmental agency that are just carrying on day-to-day tasks, but aren't charged with, say, passing policy or changing an ordinance. Those are not open meetings subject to the law. Public officials discussing an issue they have no control over. So if the zoning committee for a town wants to sit there and debate what the curriculum is going to be for next year's human growth and development, but they have zero power over it. I mean, they can do that, they can waste time, but it's not actually an open meetings violation because they are not charged with that particular duty. Another note, just a couple of things. A single public individual cannot himself or herself violate the open meetings law, which makes practical sense, right? There's one of them. How can you have a meeting with yourself? And then one that we get a lot of questions on is actually something that a lot of people don't know, which is that a government body does not technically have to allow time for public comment during, say, a common council meeting or a zoning board meeting. I mean, it's a best practice. It's something that we would hope that most government entities would continue to do, but it is not in and of itself an open meetings violation to just have the public officials debating whatever the issue is, rather than allowing each person who shows up to the meeting 3 minutes to comment. That's not a violation of the law, technically speaking. Okay, so notice issues. Generally, public bodies need to provide at least 24 hours notice unless there are special circumstances that do not make that possible, in which case even they're required to provide 2 hours of notice in most cases. The way that most folks do it nowadays is they use the internet, right? They use the website, everything's very publicly accessible there, as well as physically posting still the old-fashioned way, often wherever the meeting is going to be held or in a public place where people can be apprised of when the meeting is and what's going to be discussed. The notice has to be sufficient to actually put you as a member of the public on notice of what will be discussed. It does not have to be chapter and verse of what a particular proposal is, but it's one thing to say, all right, the Common Council is getting together to discuss new business related to potential development. Probably not great. But if they post a notice that says we're getting together on this date at this time to discuss the development of the future Frame Park subdivision located at the corner of this street and this street or whatever, that's going to give people a flavor of what's actually going to be discussed and whether they're going to be interested in showing up and potentially either, expressing an opinion if that's available or simply becoming informed on the issue or not. All right, I will throw that over to Lucas for closed sessions.
Yeah, so anybody who really follows government, especially local government, has probably experienced a closed session before. So a closed session is a session that they basically throw the public out and they turn off the cameras. It's kind of a behind closed doors meeting. So when government is allowed to do this in certain limited cases. So when they're going to do it, though, they have to, in the notice for the public meeting, they have to provide notice that they are going to or may be going into closed session. That notice has to be specific, right? So they have to cite the appropriate statutory exemption, and they have to explain, briefly, but with enough specificity as to why that statutory exemption applies to what they're going to do. So you have to be able to know what they're doing. It's not enough to just say, hey, pursuant to this exemption, we're going to be going into closed session. You have to say, pursuant to this exemption, we're going into closed session to discuss litigation involving the city or something along those lines. The local or the entity that's going into closed session cannot go into closed session and then come back out into open session and continue their meeting or go on for their open session unless they have noticed that ahead of time. So if they're going to go open, closed, open, which does happen, they have to include that in the notice. If they don't, once they're in closed session, they would have to be done, and then they'd have to renotice another public meeting before they could meet again in open session. Some of the reasons for closed session, and these are laid out in the statute, but just to summarize, if they're involved in litigation and they're talking about litigation strategy, or they're seeking legal advice from a government attorney, they're allowed to go into closed session. That makes sense, because otherwise, trust me, I'd love to sit in on those meetings as an attorney who sues a lot of local governments, but it makes a lot of sense that they'd be able to get their own advice from their own attorney without me watching. And then if there's things like personnel matters, like they're debating who they should give a promotion to, or disciplinary action against someone, and they're debating whether they're going to take that can be behind closed doors. And then some bidding discussions can also happen in closed session. A government body, though, however, may not close a session if the sole reason is to debate amongst themselves on a controversial subject, but to avoid, the public seeing them do it. So if there's something that's kind of unpopular and maybe the members of the committee want to, have an open discussion with each other, but they're afraid to do so in front of their constituents, they're not allowed to go into just closed session for that purpose. They also can't do it if the sole purpose is to prevent a member of the public from recording the meeting. Or as we note here, to hide how a body or a member is going to vote on a particular issue. Litigation. So what do you do when you spot some of these violations? I would say the one thing that I see probably the most common here, and I don't know if Kate would agree, but is notice violations for closed session. They're usually, frankly, they're usually just not sufficient. We see it all the time. That is a lot, and oftentimes they'll say we're going into closed session pursuant to the statute, and that's it. That's not enough. They have to actually give you more. That said, litigation for an open meetings violation is a little different than litigation for a public records violation. So unlike a public records violation, you don't just go immediately to court to sue on this. You actually have to refer the matter to the district attorney in your county or to the attorney general first. You have to do that. And then once you wait 20 days, the attorney general or the district attorney has first crack, so to speak, to bring that action to remedy the open meetings violation. If they do not, then you can go ahead and bring it yourself, and you've got a 2-year statute of limitations to do that. The remedies here are also slightly different. You can still get your fees, your attorney fees in this case. Forfeitures can be imposed on those involved. So fines against the public entity or the members of the entity who violated the open meetings law. But you don't get damages like you would under public records law. There are no damages available to you in closed meetings situations. So some practical tips here then for holding government officials accountable. Just know what's going on in your community. If you have concerns about a change to an ordinance or a curriculum or anything else that could be going on at your county, it's always best to bring those up as soon as possible. Don't wait until the final vote's being taken and there's not much you can do about it. Pay attention and get in there early. Litigation should always be a last resort, not the first option. This is what we always tell our clients when they reach out to us, hey, have you exhausted all your other options to remedy this yet? Because we don't want to be the ones rushing into court on every single case. There's oftentimes many things at least could be remedied short of litigation, and that's always the best option for everybody. Communicate your concerns with your elected officials. As Kate said, they don't have to give you time to speak at public meetings, but they do have to take your comments, right? So if you're going to submit something to them later, you have a constitutional right to petition your government for redress of grievances. You can send them a letter, you can send them an email, but it's very important that you remember everything you send them is also a public record. So anybody could be reading that. I can say for certain from my time working for when I worked in government, you get some not nice emails from people sometimes, and those are public records. People can request them, and they sometimes will turn up and request that people get. And so just remember, anything you send out there is public. If you wouldn't want to read it on the front page of the newspaper, don't put it in writing and send it to somebody. And as we know here, good citizens make good leaders, whether you're in official positions or not. Government works best when we all work together, and just understand that our friends and neighbors who work in government have a job to do. And in most every case, they're going to help you out as much as they can. When they don't, and when litigation becomes necessary, that's important that those actions be taken. But in most cases, just you can work with these individuals to get what you need, and we always strongly encourage that. So with that, Kate and I just want to say thank you for tuning in today. If you haven't got a hard copy of our Citizens Guide to Open Government, we do have them hot off the press. It's available in PDF form on our website. We're also happy to show up and present to groups, individuals, anyone all around the state. If anybody's interested in this work, we'd love to chat with you more about it. I am going to turn off the screen share here, and I guess I will check. It doesn't look like we have any questions that have come in. So if anybody does have any questions, we'd be happy to take those. Otherwise, we will wrap up the webinar today. And if you do have questions going forward, you can always reach out to us here at Will on our website at will-law.org. We have a contact an attorney form on there. You can fill that out. If you think maybe there's been a public records violation or an open meetings violation, we will always take a look at it. And as I said, in some cases, those are best handled by other attorneys that wouldn't be us. We just got a couple of questions that came in. Can we get a copy of the webinar to watch? Yes, this will be posted on our website, and anybody can watch it at any time. And then question here says, what if the records request says deleted email? So government officials, and Kate, you can jump in on this too. I'm sorry to be monopolizing this, but government officials have a duty to retain records. They, in many cases, the legislature is a little different, but in many cases, they are required to hold on to those emails. So they can't just delete them. That would be a violation of the public records law if they are deleting emails, especially if they're deleting emails after you request them. That's a very serious problem. That's when you're talking, potential for punitive damages in those cases. Anything I missed on that, Kate?
I mean, I would agree with all of that. I would say, yeah, deleted emails. The one exception to that is, the legislature, oddly enough, does not actually have a duty in statute. They're not defined as this sort of authority where they don't actually have to keep them. But as Lucas pointed out, like if somebody deletes in response to a request, that is absolutely not allowed. Like you're not allowed to do that and say, oh no, they're gone. That's absolutely cause probably for punitive damages and other types of sanctions. But the other thing I'll keep in mind too is if somebody doesn't have, like if a public official does not have emails from, say, 10 years ago or 15 years ago. That's likely not a violation because records retention policies are in place. And, think about, do you keep all of your emails from 15 years ago? Most people don't. It's a best practice not to. It's a best practice to just keep however long you're supposed to keep them. If you're a public official, there's a schedule usually for how often you are to delete emails. But yeah, basically speaking, you're not supposed to be deleting, and certainly not in response to a public records request.
Yeah, we just got a follow-up question. What if it's deleted using Facebook Messenger or one of those services? I talked a little bit about this when I was talking about the types of records to request, right? So there's a lot of apps out there, messaging apps like Signal, for example, that are automatically set up to delete as soon as you send it. Certain public officials who have a duty to retain their records cannot use those apps for official business. That would be unlawful. It's an end run around the public records law. So if they are using an app or a messaging service for public business, I would say probably the way to do that, if it's going to delete automatically, is they have to take a screenshot of it and retain it, and then turn it over if it's requested. They can't use something that would do that. That would be a problem. One more request that just came in. What if someone in the legislature refuses to comply? Is there any options? Kate, you want to answer that?
Yeah, I mean, because the legislature is not defined as an authority in the same way that most other public officials are, there's not necessarily, again, the same obligation to comply, or the writ of mandamus option is not as readily available to you as if, say, you were going for the governor or the mayor or other people who are defined as an authority. But that said, I think that probably the best way to deal with that is, if there's a policy fix out there for the legislature to pass, and perhaps not surprisingly, one has not passed at this point, because why would you make yourself subject to the law? It's kind of a screwy thing. But I will say that if you have independent third-party evidence, for example, that something exists and was deleted, there might be a different cause of action there. But generally speaking, yeah, members of the legislature are not subject to this the same way that other public officials are, right or wrong, unfortunately.
And then one question just came in. How do you find the custodian of the records? That depends on what the record is, actually. In a lot of cases, when we send a public records request, we always include a line that says, if you're not the custodian of these records, please forward it to whoever is, or let me know so that I can find out who the custodian is. You might need to call. Sometimes it's posted on their website. They could have a records policy. But it's pretty easy generally to find out who the custodian would be. Either calling around or poking around their website, you should be able to track that down.
Yep. I would agree with that. And I also wholeheartedly agree with Lucas's just inclusion. When you make a request, just always include something similar to that. If you are not the proper person who's going to be addressing this, please forward it, or please advise me of the person who is, and then you can start a chain with that person instead.
Well, seeing no other questions, thank you again for tuning in today. We really appreciate your time. Hopefully this video has been helpful for you. Hopefully our Citizens Guide to Open Government is helpful for you. If you run into trouble, reach out to us, reach out to another expert attorney like the Wisconsin Transparency Project. There's a lot of great folks out there doing this work, and we want to make sure that we all hold government accountable and do so in the right way. So thanks again, and we look forward to talking with you all again soon.